Well, hello there and welcome to the Disability Law Show. It's good to have you along for another ride. Over the course of this half hour, you will learn lots, that's for sure. John Scholes here, always hosting, and with me, Tamar Agopian from Samfiru, Tumarkin, LLP. Reach out to Tamar anytime, stlawyers.ca. Phone number, how about that first? 1-855-821-5900, or email is help@disabilityrights.ca. We do a lot of things on the show. It's either emails or a combination of email plus phone calls from one of our radio shows that Tamar and I do every week, and so much more. In addition to those, we're going to get to our main topic. We have one of those every week as well. Guide to long-term disability benefits and employment. They're always important topics and always worth sticking around for as well. So that's all coming up very shortly. But tomorrow we always start off with a case of the day, something of interest. What do you got, pal?
So something of interest. Since we're featuring LTD and employment today, I thought I would start off with a topic that I've been dealing with a couple of clients actually, and it's the idea of what happens during a parental leave with your disability benefits. And so the two clients I have happen to be women, but this impacts men as much as it does women, any parents really, because there is a section in these disability policies that say if you're on a parental leave, you are not entitled to disability benefits. And so, look, my own personal view of this is that I think this is inherently discriminatory. I really have a hard time with this exclusion in most disability policies. But I thought I would start off our show talking about it because we don't see this situation come up quite a lot. And it is a question that we see a little bit, particularly from women, but also from men now that parental leave is becoming much more common. And so the idea behind this provision, back in the day, the insurance companies realized that if you are on a maternity leave, at least in most of the provinces in this country, you're also entitled to typically government-sponsored benefits as well, something like EI. And so employment insurance or unemployment insurance is something that you qualify for, particularly if you're a woman who's on a maternity leave. And one of the requirements at the time was this status of quote-unquote disability. A maternity leave was lined up and equaled a disability at that time to give or warrant people this kind of benefit. And so insurance companies, in their wisdom, much like everything else that they do in their policies, they want to make sure that they're getting credits where credits are due, and this is one of the ways that they get a credit, is that if you are entitled to a different government-sponsored benefit that is quote-unquote stemming from a disability, they are entitled to get a credit, or at least build into their policies that you're not entitled to double recover. You can't also get disability benefits and get the government-sponsored benefit. But it doesn't quite read that way in the policies, John, and this is what frustrates me, is that it says that if you take a maternity leave or a parental leave during a period where you've got a disability, you're not entitled to the disability benefit for however long you are taking this leave. And so this situation, as I said, came up with two different clients. In one instance, it's a client whose disability was mental health related. She's been off for a while and actually has just learned that she was pregnant unexpectedly. That's one situation. And the other one was a client where she was off on disability before she had her child, and then has now completed the maternity leave period and is still not getting the sign-off from her own doctor to return back to work. Gotcha. And so in both of those instances, two different insurers, they're using this clause to say, you don't get disability benefits. Or at the very least, it pauses your entitlement to disability benefits. But John, they're taking it one step further. And this is where I get hot and bothered, which is the underlying assumptions that the insurance company is making in both of these clients' situations, which, by the way, are totally different, but both relying on this term in the policy, is to say, well, you were able to build your family, you're able to care for a baby, you're able to do these kinds of things, and therefore it must mean that you're not disabled enough. And so this is underlying some of the things that they're hearing from the disability insurer, which is why we're acting for both of these insurers, or against both of these insurers for these two clients. It's touchy because it should be. It cannot be the situation where we see this with a lot of mental health claims, right? Where they say, we think you can do X and therefore you can do Y. They will look at this level of function and they'll say, well, it must therefore mean because you can do basic things, like caring for your family, which everyone would do in any instance, that therefore you're not disabled enough and either should be returning back to work or are not entitled to disability benefits for whatever period that's covered under our exclusions. The main takeaway here is that it's not correct. And it's not correct for a whole host of reasons, most of which has to do with parental rights and human rights and these kinds of things. But at the end of the day, even the analysis the insurance company is using in these two instances, and that I see in a lot of circumstances, is not correct, because they tend to use their insurance policies and exclusions like this almost like a weapon. They use it as a sword as opposed to a shield. So remember what I described. This was meant to protect the insurers so that people are accessing different benefits in different periods of time. But now what we're seeing them do is use it as a way to either cut off claims or not approve claims or not pay claims because of these kinds of terms and conditions in their policies. And so when we see these kinds of situations, John, we're all over it, right? This is a great breeding ground for us to start these legal claims and advocate for people who otherwise don't necessarily have the bandwidth to do that. Not only are they dealing with health issues, but they've also got a young family or preparing for a young family. They're trying to figure this out. It's impacting younger people. A lot of the time we don't see younger people being impacted in this way, and we're seeing very aggressive responses by insurance companies. Why? Because these younger individuals who might be in their late 20s and their 30s, even into their late 30s, have a long runway until that policy goes to age 65.
Yeah, good point.
So it's a huge exposure for these insurance companies, and if they can grapple and use these parts of their policies in a way to deter people to assert their legal rights, they will do it. And so my main takeaway here is that I don't want to see this happen to people. It's not correct in the way that the insurance company has analyzed it. And by all means, at least give me a call and let's have a chat about it, and let me see if this is right in terms of what the insurance company is saying to you about their exclusion and their policy and denying benefits.
What's the first thing you go after them with? There's a million things you could go after them. How do you attack this off the hop?
So I think that the key really is that they meet the test of disability. I think that has to be the starting point. If your doctors are supporting that you cannot work, regardless of your family circumstances, regardless of what's happening with parental leave and this kind of thing, if at the end of the day you have a standalone disability that your doctor is saying prevent you from working, either returning to work or continuing to work, then you should be qualifying for disability benefits. The test is total disability from the essential duties, typically of your own occupation, at least in the initial phases. And so in my mind, any sort of legal claim would have that as a starting point, with a very quick second of, is this a breach of human rights? Is this bad faith? There are so many things that we incorporate into our legal claims, John, so that we create that leverage. We want to be able to talk to their lawyers and say, if you play this out and you have a judge weighing in on this, you're not going to win on this argument. Your decision is not correct. It's neither correct in law nor correct in terms of the optics of it. And this creates excellent opportunity for us to get the compensation that our clients deserve, that they should have gotten from the start, and thankfully have asserted in the context of a legal claim with our help.
Sometimes you'll have questions and you want to ask Tamar, and maybe for some reason, I can't imagine why you wouldn't want to pick up a phone and talk to Tamar. She's brilliant, she's so nice, and she's sweet. But there's an answer. That's pocketdisabilitylawyer.ca. It's basically kind of an assessment tool, right? Tamar, you've used it. What do you think about it?
I love this tool. I love this tool because it levels the playing field between insurers and claimants, and it allows people to simply access the website, drop down menus, super simple, super straightforward to use, and it's anonymous. And so if they don't want to actually speak with us, but they want to understand what their rights are as a starting point, this is a great tool for that. And if they want to take that additional step and speak with us, there's an option to say yes, and we'll contact them and we'll have a full consultation.
You can do that. You can join us on the weekly radio shows as well. Disabilityrights.ca. There's like a media tab there. You can find a station in your market where you can tune in, and always encourage on that show, the radio shows, to call in live and talk to us and ask your questions. We'll get to a phone call from one of our radio shows because it's worth talking about for sure. And let's have a listen right now.
I used up my short-term disability. My insurance denied my first long-term disability. Even after I had my doctor's notes, my psychiatrist's note, they said it wasn't sufficient information, which whatever question they asked, my doctors fulfilled that. They'd send them all the information. So now they declined me for the second time. Well, it's been over a year and a half that I haven't got paid.
They love that insufficient medical information.
Don't they?
Yeah, it's a good one.
And so what our caller tells us is that I picked up on the psychiatrist and the family doctor. And so I assume this is primarily a mental health claim. And as we talk about time and again, mental health claims seem to have a greater incident of denial by disability insurers. And continuing to be denied. So he tells us that he's tried to transition from short-term to long-term. It's been 1.5 years without funds, and he's still trying to beat his head against this wall of trying to get the insurance company to approve the claim. And so I would like to actually help this caller. I think we should have a consultation after our show, but to deal with his questions directly, it's this. The quality of the information that you're supplying to the disability insurer are important. If it's a one-liner note from your doctor saying that you can't work, that will not be good enough for the disability insurer, okay? It may be good enough for your employer, but the disability insurer, especially with a mental health claim, needs lots more information. They need all of the symptoms, they need your diagnoses, they need to understand very clearly what the prognosis is, what the treatment plan. All of those details are critical to have that information over to the insurance company for their consideration. But more importantly, you don't want to be chasing your tail. If the insurance company has said no, it is highly unlikely they're going to say yes after you say pretty please and send more information and go through this appeal process. John, I mean, the challenge with this is that it wears you down. And if you're already dealing with your health conditions, you're just going to give up. That's what they want you to do, especially if he was approved already for short term and now they're resisting the long term. So one of my theories is this: I suspect the insurance company reviews and adjudicates and administers the short term, but doesn't actually pay it. I suspect that money comes from the employer, but once you transition to long term, the long-term disability benefit is likely payable by the insurance company. Right. So what they're doing is that they're acting as the gatekeeper of their own funds. They're trying to prevent that transition from short term to long term, even though the test is exactly the same. It's absolutely the same test usually to qualify for short-term and long-term. And so the fact that he is being met with this resistance tells me we need to act quickly. We need to assert these legal rights, because you also only have 2 years to sue in most jurisdictions, and that 2 years starts to run from the moment you're said no the first time. So if he's already 1.5 years into this, John, I'm very concerned that he's not only running out of energy and time, but at the end of the day, may not have what it takes to actually allow us to help him, because he's probably so exhausted after going through all of this. And this is why I don't like the appeal process. I mean, there's a whole host of reasons, and I could get on my soapbox on it. But at the end of the day, it's to do what has happened in this instance, which is to continue to resist, wear people down, and force them back to work, or just to throw up their hands and say, I'm done, because they're so exhausted and so tired and dealing with all of this. But I don't want to see that happen. And I'd much prefer to help people in instances like this, because they should absolutely be approved, especially when they've been approved for short-term disability benefits.
Great phone call. We appreciate that. And the main topic, we have one every week, disability benefits and employment. What is the interplay? We'll get to that after a short break, so stick with us. It's coming right up.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Disability Law Show continues. Thank you so much for joining us this week. My name is John Scholes, Tamar Agopian. Reach out, phone number 1-855-821-5900, help at disabilityrights.ca. We always have a main topic every week because it's educational, and they're usually pretty important stepping stones to getting your mind right about dealing with that insurer. This week, Guide to Long-Term Disability Benefits and Employment. That's where we're going. Number one, Tamar, long-term disability benefit claims that are triggered due to workplace events are often, you guessed it, denied by insurers.
Of course they're denied. Of course they're denied by insurance companies. Look, before we get into this topic, I just want to preface it by saying one thing, which is this. Our firm is so well suited for this, John. This interplay is so critical because we specialize in not only disability law, but also employment law. And so we see that intersection. There's a reason why we specialize in these two areas, and it's because of this exact topic. When people come to us and they say, I've been denied disability benefits because the employer or the insurance company is saying this is all employment related. Why is that? My doctor is saying I can't work, so why is the insurance company not accepting my claim? And what we have to do as a job is to figure out, well, is this actually an employment claim or is it a disability claim? And look, most of the time it's a disability claim, and this is a way that insurance companies use to deny these claims because they'll sort of say this is all work-related, you've got to deal with HR, you've got to go through accommodation, you've got to do all of these things, and they want to send you right back to the employer. But what if your doctor is actually recommending that you stay off work? That is the starting point and is the key to this whole situation where even if your work has triggered a health issue, if that health issue is still persisting when you're out of that work setting, then it is absolutely a legitimate disability claim. Even if there is an employment component, and of course we can deal with that, the starting point in situations like this is to pursue the disability benefit. That's what it's there for. And if your doctor's saying you can't work, then the insurance company's got it wrong. And I get the situation where they don't want to get involved in a crappy work situation, right? That's not what disability benefits are there for. If there's a conflict between yourself and your employer, you know, it can't be an excuse that you're just taking a medical leave. That doesn't work. But the vast majority of people are not in that situation, John. And I think the fact that insurers are all over this and they're using this as a means to deny claims just emboldens me. I just want to be advocating for people like this because it's not quite correct. And the most of the time, even when people are outside of that triggering situation in the work setting, they've probably got a lot more going on and they need the time to get better, to heal, and they need the financial support from the disability insurer.
Yeah. Second point is this, Tamar, even if you are cut off benefits from the LTD benefits, you do not have to return to work unless you're given approval, as you said, by the doctor. It's all about your medical team.
It's all about your medical team. The starting point always in situations like this is what are your own doctors, what's your own practitioner saying about your ability to work? Look, insurance companies want you back at work. They want to push you back on because that way they win. They don't have to pay you anymore and you're off claim and they've got a way to close out their file. And they'll be very aggressive in doing that. But in situations like this, you want to make sure you're following your own medical team's advice about a return to work, regardless of what the disability insurer does. We can take care of that part. But if you put yourself into a situation where you've gone back to work too soon or you're compromising your health because you feel you have no choice, that's not a good recipe for success. And your employer does have to work with you in this process. They have a duty to accommodate. It's procedural, it's substantive. There's, you know, law around that. We've got a whole host of shows around the duty to accommodate. But at the end of the day, it is a process. And whether the disability insurer wants to support these individuals, John, in that process is separate and apart on whether or not they should be in that process at all, right? And so again, the starting point is, if you're not ready to return and your doctors are saying you shouldn't be returning, then do not return. Follow your own medical advice.
Again, we're talking about disability benefits and employment, the interplay of both those, right? The third point we'll make on this one tomorrow. And this one probably has a couple different ways we can go, but long-term disability benefits should continue despite a termination of employment for whatever reason. You get fired, they shut down the department, you don't have a job.
Right. It is separate and apart. Even though the vast majority of disability benefits that we talk about on our shows are usually group disability benefits. They are benefits that most people have by virtue of being employed and your employer's paying premiums or you're paying premiums, but you're part of a group plan. And so the question that we get oftentimes is, well, what if I'm not employed anymore? Does that mean my LTD benefits end as well? Well, no, not necessarily. If you're already on claim and getting your disability benefits, then theoretically, regardless of what happens with your employment, those benefits should continue. Similarly, if you get terminated, but you've got a disability that arose during that notice period in your termination, you can actually initiate a disability claim in that time frame as well. It gets really complicated, and so if you have more questions arising out of this, please don't hesitate to call us. Our consultations are absolutely free, and I can help you and talk you through what your rights are. But they are separate and apart, and there could be a basis of not only an improper termination, a wrongful termination claim against your employer, But also, if the LTD insurer follows suit and cuts you off in a situation like that, well, guess what? There's a claim against your insurer as well. And so this is a really big myth that people just assume if I get terminated, I don't get LTD, or I shouldn't be terminated at all if I'm on LTD. That may not necessarily be true, but yes, your employer is in a lot of hot water if they're using your medical status as a reason to terminate you. So again, this is why we're so well suited. There's lots of interplay, there's lots of overlap. And the key is that we want people to have information about what their rights are so that they're not leaving money on the table. They're getting their full compensation for severance. They're getting their full LTD benefit entitlements. But you've got to take that initial step in getting that advice. And all we can do is inform and advise and then make that decision with you as to whether it makes sense to pursue one or both your employer and your disability insurer for benefits and compensation.
And quickly, the reverse is often true. You'll get word that the disability insurer is going to cut you off. The employer says, oh, is that right? Well, you better get back to work on Monday.
100%. I actually just had a call that's exactly that instance where there's a notification that they got from the disability insurer saying, look, you're coming up to your 2 years. We don't think you're going to qualify. We're paying you for a couple of months. And within a week, his employer has decided to terminate his employment. And so guess what? We're definitely getting involved in a situation like that.
We have emails to answer. We got a few minutes to do so we'll get to that after a short break. In the meantime, write it down. Reach out to Tamar with your own business, 1-855-821-5900, help@disabilityrights.ca. We'll continue more of the Disability Law Show. Hang in there.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. A few minutes to go here on the show. We always love getting your emails, not only just for the show, but on the radio show as well. Just keep sending them. It might appear on this show as well. How do you do it? help@disabilityrights.ca, or just a phone call is good, 1-855-821-5900. Okay, here we go, Tamar. Jack this time says, my disability insurer wants me to do exercise therapy and a transferable skills analysis. I told them I'm willing to begin the rehabilitation program, but did not consent to anything else. I was employed at my job for over 20 years. If I can return to work eventually, I want to go back to my job, not a position that won't pay close to what I'm getting paid now. Do I have to consent to this?
This is a good question, Jack, and so let's dive in because there's a couple of things going on here. One is to do with the transferable skills analysis. Do I have to agree to it? And the other aspect of it is, what if I want to go back to my own job? And so look, the challenge we face is that the insurance companies have set up these policies with almost like an exit strategy. And that exit strategy is what we call the change of definition review. And so what Jack's assessment will look like from the disability insurer is first to do with whether he can go back to that job that he's had for 20 years and whether his health prevents him from doing that. And it certainly sounds like from his email that it has. And then when you get to that 2-year mark usually, so after 24 months of payments, then the insurance company will look to see, is there something else you can do? What is your education, training, and experience? And then they'll look and assess and see what are your restrictions and is there some other job that you can do? And why they do that is because the test to continue to qualify under the policy, under most policies, changes and arguably becomes tougher to meet after that 2-year mark. And the insurance company is no longer interested whether Jack can go back to his long-time employment. Even if Jack wants to, that's not going to factor into the insurance company's assessment because they've written that policy and they've written it for a reason to allow them to close out most claims at that 2-year mark because they will do exactly that. They will look at the background, the education, they'll look at the restrictions and limitations, and they will peg other jobs that Jack can do that pay him roughly the LTD benefit, which we know is 2/3 of what he was actually making. So I absolutely sympathize with this situation, John, because it's not really fair, right? If you do actually want to get back to the job that you've been doing, that you love, that you want to get back to, it's not really fair to have to submit yourself through this process with the insurance company, to have to do their rehab, to have to continue to cooperate with their efforts. But you sort of have to, unfortunately. There is a mutual duty to cooperate with your insurance company. Yes, they owe you a duty of good faith, but you also owe that mutual duty to them not to interfere in what is inevitable. And as much as I think that Jack probably requires disability benefits past that 2-year mark, he can't prevent from that reality happening just by virtue of saying, I'm not going to consent to giving you my background information. I always encourage people to cooperate with the insurer's efforts. And if they don't do right by you, and they oftentimes don't, please do contact us. We can assist in a situation like this. And it is a separate process from whatever's happening with his employment, like we talked about in our prior segment about how that works with his employment. But Jack not being willing to provide this analysis that's going to happen anyway, I don't think gets him further. No. I think where it becomes a bit more problematic is the rehab program. If the program doesn't align with his ability to do the program, that's really where I think the answer is for Jack, is to say, look, my doctors don't think this is going to be worthwhile. I'm not ready to do this program, and I'm not ready to go through this process, and sort of see through what the insurance company is doing, which is doing everything they typically do to try and bring these claims to a close. And so, yes, do cooperate, but make sure that your own medical team is involved as this process is going to happen. It's going to happen regardless, and the insurance company is going to make a decision. And if they make the wrong decision, you have choices. And one of those choices is to retain a disability lawyer and let us help you fight this.
You bet. I think we got time to get Mitch in here. One more email. How about that? Mitch says, after contracting COVID-19, my wife has suffered from continuous brain fog, chronic fatigue, and debilitating chest pains. Despite rigorous testing, there's no official diagnosis. She was denied LTD and told she should be able to continue her receptionist position despite her doctor's support that she is currently unemployable. We've been told we can appeal this decision. Do we have any other options?
Yes, there are lots of different options, but the number one option is you've got to assert your legal rights in this situation. Mitch, please let us help you. It sounds to me like your wife has long COVID, and because of the long COVID scenario, we're seeing a lot of resistance with these claims at that 2-year mark. Insurance companies don't want to be the first ones to get an adverse decision in court about this. And so they are going to be very motivated to try and resolve these claims. And we have lots of active claims where we're dealing with people and advocating with people who have the same profile. Just because there's no clear diagnosis, just because there's no good understanding around long COVID, doesn't mean there isn't an entitlement to these benefits, especially when the doctor is saying that you cannot work. That is the key. And so whether it's long COVID, whether it's been diagnosed, the key are the symptoms and allowing us to help you fight this with the insurance company. I don't like appeals in scenarios like this because they are not well understood conditions, and you're just going to get an adjuster who doesn't have any medical background saying, nope, you don't qualify. And then saying, but if you want to submit more medical, we'll look at this again and consider it time and again. And you're just running down that clock instead of allowing someone like us, someone like myself, someone on our team to help advocate. Because I have a very good sense that this will end in the success that we've seen for all of our clients in situations like this.
And with that, we are just about done. Continue to reach out to Tamar. Maybe your letters will appear on a future show, but I'll wrap up with the contact information as always. Phone number 1-855-821-5900, help@disabilityrights.ca. And you can also use LTDFAQ.ca as well. More education for you. We'll catch you next time right here on the Disability Law Show.